All right, let me briefly introduce our panel. I will not reintroduce Commissioner Aranoff, since you've just heard from her. To her left is someone who I suspect is no stranger to the patent bar here in Silicon Valley. Judge Ron Whyte from the Northern District of California has been actively hearing patent cases, but also participating in programs like this for a couple of decades now, and is, I think, rightly regarded as the dean of the District Court Patent Bar. To his left is Chief Judge Charles Bullock. Judge Bullock is the Chief Judge and the longest-serving judge on the International Trade Commission, and as such is responsible for hearing a number of the patent cases in the initial investigations that Commissioner Aranoff talked about. To his left is Matt Powers, again, probably no stranger to the Silicon Valley Patent Bar. Matt has had a long and illustrious career as a patent litigator and trial lawyer. He has litigated for many years at the firm of Weil Gotshal, and last year left to found his own law practice, Tensegrity Law Group, which he runs with, I don't know, how many people now? 9, 10 lawyers? 8. 8 lawyers. And finally, Stefani Shanberg. Stefani is a partner at Wilson Sonsini here in Palo Alto and a specialist in international Trade Commission litigation in the patent space. So we have a great panel, and we're just going to start our discussion. I've got a bunch of topics and questions I want to raise for the panel, but I'm also going to save some time and open it up for discussion with the audience as well. Let me start with a topic that we spent some time discussing on the last panel this morning, and that is the question of stays. There's been a lot of discussion as to whether or not a district court should stay patent litigation pending the resolution of a reexamination proceeding in the patent office. We know that a significant chunk of the ITC enforcement cases have a parallel district court case proceeding as well, with at least some of the same defendants. The number is about 65% of the cases. There's a parallel district court proceeding. What happens procedurally when you sue somebody in the district court and when you file in the ITC? Matt?
Well, usually what happens is that the defendant in the district court case, the parallel district court case, invokes their statutory automatic right to stay that case pending the outcome of the ITC case. That is, I would say, by far the lion's share of the cases that you'll see. The interesting corner cases are cases where there are different defendants in the parallel case than in the ITC case, or where, and this has happened a couple of times with me, where the patent holder tries to stay the district court case and the defendant does not. And that often arises from idiosyncratic things happening in that particular district court case, but those create interesting questions. The other interesting question comes when the patent overlap between the district court case and the ITC case is not completely coterminous. So if there are some patents asserted in the ITC as to which the automatic stay can be invoked, and there are some patents that overlap with that in the district court case, but not others. At that point, the automatic right to stay does not attach to the non-overlapping patents, but the normal district court discretionary factors about whether one would stay do, of course, apply. And you can imagine fairly quickly all of the arguments that are made back and forth about why it would make more sense to try all of the patents together, even though some of them will not be subject to the automatic stay. And you could imagine the arguments on the other side as well. But to avoid that, most sensible filers create two district court cases. One which is exactly coterminous with the number of patents and parties in the ITC, and a second district court case, perhaps even in a different district, to try to avoid consolidation and then the whole problem coming back, where the patents are not overlapping and the parties are not overlapping. So I would say most of the time the corner case issues don't arise when you have someone who's thought about the program in a sensible way. But you often get you do now, and I think increasingly get the situation where sometimes a defendant chooses not to invoke the stay because they think they can impart pressure onto the patent holder. They think they can do something which gets some discovery in the district court case which may be helpful to them. That's still by far not the majority, but that's, at least from what I've seen, increasing.
Okay. Anyone want to add to that?
I think one of the more interesting things to come up lately about the Section 1659 stay is a decision that came out of the Western District of Texas, Judge Yackel. Judge Yackel questioned the constitutionality of Section 1659, telling district courts that they must stay cases when they are coterminous with ITC investigations. He ultimately decided to grant the stay based on his discretionary authority to do so, but denied the stay under 1659 and declined to actually find 1659 unconstitutional, but nonetheless questioned it. It's an interesting opinion because I think, like what Matt said, it's common practice that you're going to have, a coterminous case in district court with an ITC investigation, and that most defendants are going to go ahead and try and stay that case. Some defendants will try to hurry that case along to get a favorable claim construction, since there are not claim construction hearings in the ITC or the like. But if you ask Judge Yackel, that practice, it should be coming under a constitutional question. And for the most part, I agree with everything Matt said. I think when you don't have identity of patents or parties, such as when you've got, an AIA case where somebody doesn't necessarily import their products, so they weren't subject to the ITC investigation, but they are in the district court case that is now going to be filed as a unique district court case, as opposed to a district court case with tons of defendants, those cases may proceed, or they may not. It's kind of like stays pending re-exam. I think it's going to be very much subject to the discretion of that district court judge and the preference of that district court judge. And, as everyone in the room has probably observed, it's wildly disparate depending on the court that you're in front of, whether or not you obtain a stay pending re-exam. And I think it'll be the same thing here, whether you obtain a stay of non-identical claims pending an ITC investigation.
The problem with that stay motion, though, is at least with the re-exam, you have the argument to the district judge that the claims could actually change. The operative claims that will apply in the case that district judge is hearing will change, may go away. You don't have that argument on a stay pending an ITC case, because the ITC's decision is not binding on the district court. And so the normal arguments that you would have for that stay really don't fly unless you happen to have a district judge that just wants the case to go away.
But I can come up with other arguments. Under Section 1659, the record from the ITC case is transferred to the district court. So some district court judges are going to find that because the ITC investigation will proceed quickly and develop a record that can be then used in the district court, that it makes sense to just go ahead and put off those other related cases and handle them all at once after the ITC investigation terminates.
Judge Whyte, what would you do in a circumstance like this? It sounds like you don't have to stay if the parties or the patents aren't identical. Maybe you have to stay as to some but not all of the cases, although after the America Invents Act, I take it that we're going to have a lot of separate cases filed against separate defendants and not a consolidated case with a lot of defendants in the same proceeding. Does it make sense to stay?
Well, let me start off by saying the only time that I've had the issue come up, and I suspect it's the same with the majority of district court judges, is when there is an ITC proceeding going forward and the defense asks for a stay, and that's the end of it. So I think these cases that Matt and Stefani are talking about are somewhat unusual. I don't know how many they've had, but I haven't seen one, and I don't know of one within our district, although maybe there has been one. I think if it occurs, you just apply your standards, whatever they are, for exercising your discretion, and that would depend on things like how much overlap is there and how quickly is it going to get resolved, and the fairness of one party being stayed and another party not being. So I think it really depends on circumstances of the individual case, and I hate to say this because it's kind of a cop-out term, a case-by-case decision.
Well, suppose you stay a proceeding pending the ITC action, and then the ITC action concludes. What happens now? Is the ITC action binding? Does it
No.
matter which way the ITC decided?
It's not binding, but I think I would certainly look at it carefully. I mean, the ITC they do a lot of patent work. They have some expertise. They spent a lot of time on it, and I think it's definitely worth taking a look and seeing what they've done, and maybe give you some guidance on what you want to do. One thing that I think you should keep in mind is that for a district court judge, he or she may have, like in a northern district, I would guess we have about, active judge has about 15 patent cases per judge at a time, out of a total of maybe 350 civil cases and another 75 criminal cases, whereas the ITC people are concentrating on patent law, and so they have definitely some expertise, and I think we'd be foolish not to take a good look at what they have to say.
One interesting question mark on that is, would district judges adopt a much faster schedule for the post-stay case to reflect the fact that intensive discovery has already been done, which need not, in most cases, be redone, and a Markman proceeding will have been briefed and done, which doesn't require perhaps the entire Markman process of the Northern District rules. And of course, the district judge may leverage off of the thoughtful decisions of the ITC. They aren't bound by them, but there's a lot that comes from that could be useful to shorten the case. And so one perhaps accommodating thing a district judge might do if they stayed the case is at least have a much more expedited schedule post-stay.
I think that's definitely a possibility or probability even. I think it would also cause there to be a pinpoint focus on a particular aspect of the claim construction that was subject of dispute, and that if you had 10 terms, probably 9 of them would be agreed upon, and the subsequent district court proceeding would focus on one particular term that was supposedly or arguably interpreted incorrectly.
Now, suppose, how does any of this change if the ITC decision is then appealed to the Federal Circuit and the Federal Circuit renders a decision? Right? So I guess the first question is, when do you relieve the stay? Is it once the ITC makes its determination, or do we wait through the Federal Circuit appeal? And if we're going to wait through the Federal Circuit appeal, then I think the question is, well, suppose the Federal Circuit held this patent invalid.
Somebody on the panel can correct me. I thought that you had to stay through the commissioner's decision, but not for the appeal to the Federal Circuit. Is that right?
Actually, Your Honor, the Federal Circuit found in a case called In re Primco that the stay stays in place until the commission opinion is no longer subject to judicial review.
So then you have to wait for the Federal Circuit to...
Yes, it seems
even a
that way.
cert petition, it sounds like.
Right.
All right, so now we've got a final determination
Shows
from
you
the
how much I know.
ITC. So what? So if we have a final determination from the ITC that the patent's invalid, is the district court case over?
I'm sorry, where did it stop?
Federal Circuit said this patent's invalid. But
I'm
first we
hesitant to speak up because I was wrong last time, but seems to me that if the Federal Circuit makes a decision, it's probably the end of it, but maybe I'm wrong.
Well, the Federal Circuit would be reviewing the ITC decision on a basis of a standard of review, which in most cases would not dispose of the patent's validity for purposes of district court. Now, you can imagine some exceptions to that, but the standard of review combined with the lack of binding nature of the ITC decision before and the different levels of review would make it not binding on the district court later, with some exceptions.
That's a little surprising, isn't it, right? I mean, we are giving the patentee 2 bites at an apple from a collateral estoppel perspective if we're doing that. Does that make any sense? I mean, why? I guess in the PTO context, the Federal Circuit just said this past week we're going to do the same thing, right? A final determination on validity in the district court doesn't prevent a contrary final determination in the patent office. Does it make sense that we ought to be ignoring or at least not binding parties to whatever the ITC's determination is once it's been gone through a process of judicial review?
You could certainly make a good argument that it's not a sensible way to run a railroad.
Well, I don't know, Judge Bullock, shouldn't the district courts simply be deferring to what you guys do? Problem solved, right?
Absolutely.
Well, so let me turn to the issue that Commissioner Aranoff spent some time talking about, and that is the role of non-practicing entities. Now, one of the difficulties in in figuring out how many non-practicing entities or patent assertion entities or trolls or whatever else, we can't even agree on a name for the entities whose character we hope to describe. It's not surprising, therefore, that we also can't agree on who exactly is one, and so numbers differ somewhat. The numbers that Colleen Chen and I have put together are a little bit higher for ITC proceedings in terms of the number of cases. We found about 25% of ITC investigations initiated in last year in 2011 were non-practicing entities of some form, and it was lower the year before that, and it has fluctuated, but it has gone up a bit certainly since eBay. But one of the things that I think is notable is that whatever the actual percentage of investigations that involve patents owned by non-practicing entities, the patents owned by non-practicing entities have a lot more respondents in the ITC cases than do other kinds of patents. And so, in fact, Colleen and I found that half of all investigations begun in 2011, half of the respondents in investigations begun in 2011 were respondents in NPE proceedings. So, what I want to think about here is the interaction between the district courts and the ITC in the wake of eBay. eBay seems to have led to a general practice in the district courts that if you're not a practicing entity, you're not going to get an injunction. There's no absolute rule, but it sure looks like most of the time that's the way it comes out. Does the ITC have the discretion to say you're a non-practicing entity and so you're not going to get an exclusion order?
They
Sure.
probably wouldn't say it exactly like that, but I think they have the discretion to deny an exclusion order based on public interest factors, and under the circumstances you describe, I think they should seriously consider it.
Well, as Commissioner Aranoff mentioned, you also have to, a non-practicing entity has to meet the domestic industry standard. If they don't meet that, they're not going to get any relief.
But on that issue, there are a lot of companies that you would not think of as being a non-practicing entity who only satisfy domestic industry under the licensing prong. Kodak satisfied domestic industry only under the licensing prong, not on any other basis. Now, does that make them a non-practicing entity? Technically, I think under the definition that Mark and others have used, often yes, but because they couldn't satisfy that. Now, the same standard that applies to the Kodaks of the world and several other very substantial companies who sell a lot of products ought to apply to NPEs. And at least my personal view on that is that the ITC rules are pretty clear about what satisfies the domestic industry, and a lot of NPEs can satisfy that test. And so this natural urge to squelch NPEs is inconsistent with the actual statutory language applying to what constitutes a domestic industry. And I think that, so if once that's satisfied, it seems to me at least quite difficult to make a public interest argument against an NPE obtaining an exclusion order merely because it's an NPE. It has satisfied the statutory requirements for getting in the door, and that requirement should apply with equal force to it and Kodak.
So if you use the definition of an NPE, let's put in our minds the troll, the one that's got perhaps the most negative sort of connotation to it. The only reason the troll is going to be for the ITC is for hold-up purposes or the fear of an injunction, is it not?
For licensing.
Well, but the ITC is not going to give you license in exchange for money, right? That the district court presumably could award a damages.
And do you think that's really different from a bunch of other non-trolls? A lot of
Well-
other non-trolls have the same objective.
Well, is that a factor we ought to take into account? I mean, we have a bunch of public interest factors that the commission is to consider. Should we be thinking about how much do you need an injunction? Do you need to actually bar these products in order to protect your business, or are you just interested in trying to get more money?
Right, so the University of California at Berkeley then becomes a troll, which could not, despite substantial licensing efforts, use the good offices of the International Trade Commission to achieve its licensing goals.
So
A lot of other companies are using the good offices of the ITC to obtain its licensing goals.
I'm interested to hear what the ITC folks think about this. Is this something that's within the power of the commission to say you don't need an exclusion order because you're not protecting the sale of actual products?
So I don't think we've ever had that question squarely presented in a case. And there's a progression, right? First, you're going to have a lot of cases that are not going to make it past the hurdle of the domestic industry requirement. And because the commission, like the courts, is working in a common law system, and we're going case by case based on the facts of the case, there were the cases that I mentioned that have really been narrowing in on what happens with the domestic industry requirement when you apply it in the case of someone who's just coming in under the licensing. So that law has been evolving on a case-by-case basis, and there are, well, the last three major ones the commission decided no one made it over that hurdle, so you didn't even get to the issue. I think I mentioned in my statistics that there have only been 3 non-practicing entities that have gotten all the way to the point of actually getting a remedy. So, there's been not much movement towards getting to this issue all the way at the end where you get to the public interest factors and actually have to consider it. The public interest factors are arguably narrower than what the president looks at, which is basically any policy argument that someone would care to make. So there's also room at that next level in the process.
Others?
Seems to me that, for again, taking the troll and the non-practicing entity that is solely just buying up patents for the purposes of asserting them and getting settlements, that there's good reason for saying that the public interest is not served by an injunction in that case, and that seems to me to be perhaps the answer is that if there are cases that appear to get to the remedy stage and it appears that they are solely for the purposes or brought there solely for the purposes of trying to get or holding the threat of an injunction over the head of the defendant, and maybe when it gets to the remedy phase, the public interest exception should be applied.
So what if Intel buys patents for the sole purpose of extracting leverage against another party in producing a worldwide settlement of something where it didn't have sufficient patents? It bought the patents the same way the NPE did. It brought the case in the ITC for the same reasons the NPE did. Why would you have different rules applying to different parties when the lines are blurring all over the place. Every major company in the ITC has bought patents. Many of the patents being used in the ITC were purchased. At some point, it's hard to draw a principled line among all those entities.
I think it's very hard to draw a principled line, but I do think, companies that buy up patents just for the purposes of increasing their inventory and for the use of a threat if they're sued, that concept bothers me.
So let me, one potential point of distinction here, right, is the question of what products will be sold in the United States after the existence of an exclusion order, right? So one difference between an Intel case, or we've seen plenty of smartphone litigation, is if I'm selling a product in the United States and I am a patent plaintiff in the ITC, if I exclude my competitor's products, well, there's still going to be products available in the marketplace. If I'm a non-practicing entity and I exclude all of the companies who are actually making products, then unless the parties later settle, there aren't going to be any products sold to fulfill that need. And the Commission has in the past talked about the availability of products to serve consumer needs as one of the public interest factors, right?
That's correct. Yeah, I mean, the one thing we know that when Congress amended Section 337 in 1988 and put in that licensing provision in the domestic industry section, they did it precisely with certain kinds of non-practicing entities in mind. They were looking at individual inventors who didn't have the resources to then go out and commercialize a product. They were looking at universities with research arms who would develop technologies and then license them to someone else. And they were looking at, in particular, the facts in the Gremlins case, which involved Warner Brothers, which had a very active licensing operation for products that were subject to, I think it was a copyright case, that were being produced abroad and then sold in the US. So Congress clearly had non-practicing entities of some specific kinds in mind when it put that licensing provision into the statute. Now, that said, the kind of business models that are in use today with respect to entities that exist to buy up and assert patents, or companies that produce with some patents and don't produce with others that they've purchased, I think it's fair to say that Congress had no idea when it amended the law in 1988 the kinds of business models that were going to grow up and that we're seeing today. And so, you really can't look at either the legislative history or the statute and know for sure what Congress meant to happen in these situations.
I think that's an excellent point, but again, the lines sort of get blurred. Often, the path of an NPE begins with an individual inventor, the same individual inventor that the licensing provision was put in to protect, who decides to exploit the patent not by licensing it individually, but by selling it to an NPE, often retaining a back-end percentage of whatever his proceeds are. And so effectively, the NPE who's being disparaged is standing in the shoes of the individual inventor and acting for that person. So then why would you benefit the individual inventor when they're doing it on their own, but not when they choose to do it through someone else, where the lines, to me, just at that point get too blurry to enforce.
What is a domestic industry through licensing? Actually, Stephanie, I'd like to hear you say something about this.
You hit on the critical question. I mean, I think the critical issue here, and the one that hasn't been squarely presented to the Commission, is whether the licensing prong of domestic industry requires satisfaction of technical prong as well as economic. And I would argue that it absolutely does. I mean, I think on this point, the legislative history is crystal clear. The congressional notes talk about the domestic industry requirement being a gatekeeper, and repeatedly, over and over again, talk about articles protected by the patent. So if you're talking about an individual inventor, a university, a startup who have articles in mind and they're licensing their patents so that somebody else can build an industry in it, then fine. But when you're talking about people who are simply buying patents and are simply motivated by revenue-driven licensing, I don't think they have any place in the ITC, because I do not think they can meet the domestic industry requirements.
So explain, walk me through the technical prong here.
Walk you through the technical prong. So when a company that actually has products sues in the ITC, they have to prove two prongs of domestic industry. They have to prove the economic prong, which means substantial investment in the articles protected by the patent, and they also have to prove that those articles practice the patent. The way that 337 has been applied in a couple of cases, and this hasn't been addressed by the commission, it hasn't been addressed recently, is to allow entities who are purely proceeding under the licensing prong of domestic industry to show substantial investment in licensing of their patent, divorced from articles protected by the patent. But if you look back at the statute, it says that you have to have an industry in the United States relating to articles protected by the patent. And then it says again that the industry shall be considered to exist if there are, with respect to articles protected by the patent, significant investments in plant and equipment, labor and capital, or exploitation through engineering, research and development, or licensing. Never does the statute say that you can only license your patent divorced from any kind of articles protected by those patents and still sue in the trade organization that is the International Trade Commission. Those are the types of cases that I think legislative history is crystal clear belong in district court. One of the things that Congress did say was that they didn't want to see the ITC become just an alternative forum for patent litigation, and they didn't want to see excessive use of the ITC. And that's precisely what I think you have here with MPEs and PAEs going to the ITC purely for revenue-driven licensing as opposed to product-driven licensing.
Now, I take it that wouldn't, well, I guess maybe I shouldn't presume this. Suppose that I had I am an individual inventor and I own a patent, or for that matter, I'm a patent assignment company and I just bought it up in order to make money from it, and then I've got an exclusive licensee who manufactures a product. I take it that's a domestic industry, even though they're not owned, they don't own the patent?
Mark, I think that I have to admit, under the current statute, that if you've got a licensee who's practicing that patent, you can satisfy domestic industry.
Right.
That said, I've been in situations before where I've been representing that unwilling licensee who has to prove up the NPE's domestic industry, and I think that's a problem. I don't think that an NPE should be able to say, hey, look over there, this guy who denied infringement but later took a license is practicing my patent, and therefore I should be able to exclude all of these other participants in the industry. That said, I think that scenario is possible under the current statute.
Well, and so then you're going to run into situations now where maybe I can say, well, hey, I sued 10 people in the district court and a bunch of them settled with me. Is that a domestic industry?
Are you talking about the fact that they took licenses through litigation?
Yep.
I mean, I think under mezzolingua, you've got a tough question on your hands there. I think that if the litigation was directed purely at revenue-driven licensing, there's an argument that those costs should not count towards domestic industry. But I also think there's an argument on the other side. The litigation costs themselves, it depends on how it all got started. And it depends on whether it can actually be tied to articles practicing the patent.
But independent of the mezzolingua question, the licensee's activities may indeed satisfy the domestic industry requirements. They are producing products. They have agreed they're licensed,
Assuming they're producing them in the United States.
assuming that.
Are we really sure that NPEs prefer the ITC if they can meet the requirements?
I think there are a number of benefits to the ITC to an MPE, and I think, I have spent a fair amount of time talking about this with people at OUII and at the commission, and everyone says this isn't the firestorm that a lot of defense attorneys think it is. I think make no mistake about it, that if an MPE can go to the ITC and avoid district court AAA misjoinder rules, avoid district court transfer motions, avoid stays pending re-exam, obtain injunctive relief that's no longer available in district court, obtain speedy recovery. I absolutely think it's an appealing forum, and I'll make one caveat there for rich MPEs, MPEs that can afford in investing to create the appearance of a domestic industry.
There's another caveat, though, and the question you're asking is a really good one, because another distinguishing feature of the ITC is that its relief is completely prospective. And a defendant has a good year and a half to think about how it might design around, design out, change whatever is being accused of infringement. And so an NPE that's thoughtful says to itself, are the claims that I would assert there ones that would withstand that process? Because otherwise I will go through all of the ITC's process and at the end have something that is not worthwhile because they will just design it out or avoid it. And so particular types of claims are going to be brought by thoughtful NPEs that will survive that. And those claims are going to be stronger and cleaner and I think better claims because there's no point for an intelligent NPE to go there unless they have claims that they think will survive that.
So they'd want some time left on the patent, too.
They definitely want some time left on the patent, and
Although we've seen cases in which people bring commission investigations in the last year of a patent life. What's that about?
seems odd to me. I wouldn't do it.
Yeah,
So it is, I mean, one of the things about the remedial structure that I think has to influence, whether consciously or subconsciously, the public interest question is the fact that, as Matt points out, the only relief the ITC can offer is prospective. If it doesn't grant an exclusion order, presumably it finds a violation of a patent, and then decides as a matter of public interest not to grant an exclusion order, it doesn't grant any relief, right? Is there a way to solve that problem, to find some in between? Could they refer the case to the district court for a damages award? Alternatively, if they're going to, if we think this is a case in which we might not grant an exclusion order, even if the patentee wins, should we figure that out up front? Should we do public interest first in some sense and avoid wasting everybody's time? I mean, Commissioner Aranoff, I know there's been a move in the commission towards greater focus on public interest information and earlier in the process. Can you talk a bit about what motivated that?
Yeah, well, as I mentioned in my remarks, I think it's the rare case where public interest comes up at all in any serious way. And, part of that is because I think there's so much, and the private practitioners can comment on this, there is so much going on at the beginning of a 337 case because they move so fast, because you're jumping right into discovery, because especially if you're on the respondent side, and those are the ones who want to raise these public interest arguments, you're, rushing around, getting counsel and getting organized and having to organize your discovery effort much faster than the complainant, who's at least had some time in advance to think about it and get organized. And I really think that people don't get their minds wrapped around the end game. They don't get all the way to the point of, what if I lose on claim construction and violation and validity and all these other things, and we get to the end and the commission's going to issue an exclusion order? Do I have a public interest argument for why that shouldn't happen? I just think that's way down the list of what people think about. Because we've seen in the rare case, but in some cases it happened, that we all get to the end of the case and everybody, the parties, the commission, we all look up and go, uh-oh, there are serious public interest issues here and we have no record. The commission has the power to go back and fix that. To an extent, that's what we did in the baseband case by holding our own hearing and having our own briefing. But you know what? It slows down the process. It costs more for the parties. And it's not as good as having the evidence brought in front of the ALJ because there's no cross-examination in front of the commission and the procedures are a little bit more informal. So there's not as much notice and opportunity to be heard and there's not as much back and forth. So all that said, that's what caused the commission to go out and say, we need to at least take a serious look at the beginning of the case and try to do a better job of identifying the ones where public interest is going to be an issue if we get all the way to the end game, and start getting that record assembled, while we have a chance to do it in a more thoughtful manner, and that's what led to the new procedures.
I mean, One thing that I think would be useful in these ITC proceedings, because you're right, they do start out at an incredibly fast pace, would be to have a jurisdictional hearing at the beginning, where we talk about things like domestic industry, importation, and perhaps public interest. I had a case once, it's been years ago, but my client manufactured their products in the United States. 100% right down the line. And we brought a summary determination motion that was never decided. And the ALJ is no longer at the ITC, so I feel free to talk about it. But it was never decided. The case ended up settling at the eve of the hearing. And this was an open and shut issue that we could have addressed at an hearing, perhaps like an initial case management conference on jurisdictional issues at the beginning of the case. So I think the Commission's done, a great job with the November 2011 rule changes, asking to develop a more fulsome record on public interest and leaving open the possibility that the ALJs will take evidence on public interest. But, having represented, a number of respondents in ITC investigations, I know the burden that they face, even just having to proceed with an investigation unnecessarily for, 3, 6, 9 months. So, that's something that doesn't require a statutory change, but is simply a rule change, or even just something that's, best practices in an ALJ's ground rules, to actually look the parties in the eye, before the case has been pending to the tune of, millions and millions of dollars and, 9 or 12 months, and talk about these jurisdictional issues. And along those lines, I actually do think these public interest factors can be jurisdictional in certain cases.
So let me, Stefani's example actually raises another point that I wanted to bring to, though it's a change in direction, and that is settlement. One of the things that Commissioner Aranoff said, which is perhaps when you think about it, quite surprising, is about 40% roughly of cases before the Commission settle. That contrasts with 85 to 90% of patent cases in the district courts settling. And the question is, why the difference? And if we think it's a problem, what can we do about it, right? Are district courts better positioned to promote settlement than the ITC? Are the parties just in a different position?
I think it's about the speed. I think it's because the ITC cases just take off and keep going. Whereas in district court, you have a lot of very useful inflection points. You have your Markman hearing, you have perhaps summary judgment hearings, and in the ITC, frequently summary determination motions go unruled upon because the pace of the investigation is just so quick.
I think that's right, and I also think just the difference in procedure influences settlement. In a district court, once that jury has ruled, it's unusual for that to get changed until you get to the Federal Circuit, perhaps. And in the ITC, people tend to go through trial because they know there's a few-month period after that where they could settle, and things have moved so quickly up until that point that they say, well, we've already spent the money, let's see what happens, and then we can sort it out after that. I'll bet that settlement rate goes up after commission decision before Federal Circuit, but I don't know when the stats were taken. I just think that the process encourages people to go through trial at least. And then once you've gone through trial, the additional burden of the commission review is not very substantial, so I think people go through that as well. And by the time you're thinking about settlement, you've already spent all the money, so parties just say, let's go see what we get.
Does the absence of a jury make a difference?
I don't think the absence of a jury makes a difference other than in what I was alluding to, because if you can sit through the ITC trial and make observations about how it went, knowing that you've got a month and a half, 2 months before a decision is going to come down, and you actually know when the decision is going to come down, at least by, and usually it's very close to that date. So people often settle shortly before the ID date, which of course is, I assume, quite frustrating to the ALJs, who by that time have spent all the effort to try to resolve it. But parties, just because they're human beings, often wait till they are forced to, and that's often when a settlement happens.
I'm never disappointed when a settlement comes.
And Judge Bullock, you've been working on settlement in your cases. You want to say a little bit about mediation at the ITC?
Well, the commission, the last couple of years, has instituted a mediation program. If the parties opt for mediation, or if the judge requires mediation, the parties get 1 free day with a mediator from a distinguished panel set up by the commission, one of whom is someone you're all familiar with, former Chief Judge Michelle of the Federal Circuit. I mandate 3 settlement conferences in every case, one of which must be mediation. And other of my colleagues do it more on a case-by-case basis. And my view is the program, I think it's very much worth the effort for the commission to have a mediation program. As everyone's aware, we have a very heavy caseload, and anything that can either settle the case in its entirety or narrow the scope of a proceeding is very welcome. And so I'm hopeful, as I say, the program's still relatively new, but I'm hopeful as time goes by and people get more, have more familiarity with the program, that it will be more successful and more cases will settle.
And do you have thoughts on sort of what causes cases to settle in the ITC? And why some settle and others don't?
I don't. That's always a mystery to me.
All right, why don't I encourage folks to come ask questions. Probably the right thing to do is come to the microphones. There are 3 of them throughout the room, and that way we can all hear you and the world at large can hear you.
So Mark, while people are putting together their questions, I had one thought that I thought would be relevant to what we're talking about. I mean, for me at least, one of the biggest lessons of thinking about the ITC versus district courts is the most obvious, which is you can get a well-reasoned, solid, good decision on the merits in the ITC about half the time that you can get it in most district courts. And I think one of the things that we as a community thinking about all these things ought to be considering is the overall time to resolution of a dispute. Because patent holders have various interests in the system, one of which is not to be locked up in various proceedings for 10 years. Defendants have an interest in having a reasoned decision on the merits that is of sufficient quality and sufficiently deliberative to produce the right decision. The system has interests in trying to reduce the costs of providing all of that. And at least one of the things we ought to try to think about, I think, is how in the district courts, maybe using the pilot program as a vehicle for thinking about it, how we might produce the same result for patent holders in the district courts that the ITC can provide. Now, obviously, there are differences. You don't have damages in the ITC, but you do in the district courts. You have domestic industry, which is close, probably not quite as burdensome, but close. District judges have many, many other cases to do, but maybe the pilot program is a way of trying to solve that. So I think if you address that issue, then some of the concerns about NPEs using the ITC might reduce. You might sort of eliminate some of the anomalies in the system that result from the ITC being such a preferable venue based on things that the district court might actually be able to do in terms of speed, certainty of timing, those sorts of things. Because it's not just raw speed. The certainty of timing is often at least as valuable. In the district court, you can have a trial that's set 2 years out, and it ends up being 6 years out for a variety of reasons. And obviously, everybody in that system is trying to do their best, but their best is in the district courts is on average twice as long as the ITC. And that's something we all ought to think about.
I think you've got a very good point. I think one of the biggest frustrations, certainly to me personally, and I think a lot of district judges, is the time to get thoughtful orders out, or at least what you hope are thoughtful orders. If you get certain other types of cases, criminal cases, that you just don't have a choice as to when you get it done. And my own view is, and I think we may see it, is that if we have a culture change on what is permissible discovery, that's probably the one biggest step that could be taken to get decisions made more quickly in the district courts. But discovery is so wide-ranging, or has been, that I think it's been a real problem for getting things done quickly. And I commend the work that's been done with trying to come up with some ways to curtail unneeded electronic discovery.
Okay, question?
I just wanted to ask a little more about eBay's direct effect. Is it in some way, I understand it's a little ahistorical, but do we say if the Supreme Court's saying these cases don't deserve injunction, then that's binding on the ITC, then that's in some way implies that we don't want disparate outcomes where the very fact the Supreme Court said can't happen is now happening somewhere else?
So it's what's the answer is, and the Federal Circuit confirmed this in a 2010 opinion, the ITC is subject to its own statute, and that statute says if it finds a violation of Section 337, it shall exclude products from the market unless it finds that the exclusion would not be in the public interest. The Federal Circuit said that statute does not apply traditional judicial principles of equity, and so the four-factor test that the court created in eBay simply doesn't apply at the ITC. So the result has been that if you're a non-practicing entity, your odds of getting an injunction in the district court are quite low unless you fall into a couple of categories, individuals or universities who've had a better shot at it. But that's not been true at the ITC, and there haven't been any cases since eBay where the ITC has found a violation and has denied injunctive relief, denied exclusion order altogether, though there have been cases where they have stayed or delayed implementation of the order.
I was interested a little more in the mediation process at the ITC as opposed to, for example, jams here in the Northern District. From a procedural point of view, you have enough background to understand what the process actually is for mediation? Do you require the parties to submit some opening statements? Do you allow the parties to sit across the table? Or is it, how does that fundamentally work?
Well, from the point of view of one of the administrative law judges at the ITC, we require that all parties, or I'll speak for myself, I require that all parties be present and meet in person with the mediator. At that point, and again, it's for one day, at that point then it's up to the mediator to set the procedures for how he or she wishes to proceed. So we don't get involved in the second part of it.
I mean, one of the
one
things that
follow-up.
we've done is
Okay.
we want to keep the mediation process separate from the trial process by completely keeping the two screened off from each other. So the administrative law judge can send a case to mediation, but he can't know anything about what's going on in the mediation, none of which will be revealed to him. And that's the same for basically everyone else at the commission, except the one person in the secretary's office who works out the schedule and finds a room for the mediation.
In terms of requiring the parties to be there, how do you require the decision makers to be there for the litigants? Is that an issue? I mean, oftentimes, too often, you go to mediation and the real decision makers are not there. The parties have to go back and talk, which is not one that I promote. But, so having the real decision makers there on the spot can make decisions, narrow the issues. How do you get into that?
Well, I just direct that they be there, and I haven't had a problem with that. I've had parties request to say, well, can I participate by telephone, or it's too hard, and I've pretty universally said, no, everyone has to be there, and you must have people there who can make decisions. And so far, that's worked out okay.
Thank you.
Carl.
Thank you.
Yes, I'd like to ask whether it's possible for the ITC to articulate how they would implement the public interest standard or test, particularly for non-practicing entities. it strikes me that it's pretty clear from the underlying economics that an exclusion order can be too strong a weapon, let's say, in cases, particularly in the information technology sector, where there are many patents and the ability to exclude entire product would give too much bargaining power to the patent holder. So that suggests that we really want to rely more on the district courts, the topic of this panel being the interface with the district courts. So when the patent holder, of course, has the opportunity to pursue, to obtain licenses and an infringement decision in the district court, it certainly seems like it would be helpful for the ITC to indicate when they would basically say, we're going to apply, actually along the lines of what Director Kapos indicated, say early in the process how this is going to work, that we're going to apply a standard where, for a non-practicing entity where it's simply a matter of getting leverage, that we'll leave that more to the district courts, at least under certain fact patterns, and we will announce to the world that we will apply the public interest standard in that way. Is that something the ITC could do? And if so, why not? Why haven't they done it yet then?
Okay, so the short answer to the question is no.
You can't do it, you mean?
Can't do it. Because unlike the PTO is a policy-making agency, it's part of the administration, it can create a policy on behalf of the president. The ITC is a quasi-judicial institution. We're a creature of statute, and like a court, we can only decide the cases one by one on the basis of the facts that are in front of us. We're not going to go out and articulate a policy in advance of a specific case that squarely raises the issue.
Okay, you've caused me to have my colleague, Artie Wright, come here.
Yeah.
The follow-up question.
This is great, because this is the question I wanted to ask. So the NLRB does all of its policymaking through adjudication. Why is it that you can't do policymaking through adjudication? I don't understand that as an administrative law matter. I mean, maybe you can't direct your ALJs on what to do, but can't you come up with a pattern of cases that just kind of help to frame what public interest means?
I think that's what we have been doing with domestic industry, with the domestic industry requirement. As the fact patterns are laid before us, we've tried to really think hard and lay out some standards which apply to the facts in that case and hopefully will make sense in the facts of other cases that we haven't seen yet and can't quite imagine.
Right, so I would just suggest that I don't think you're not a policymaking institution. I mean, there are lots of adjudicatory bodies that are agencies that do policymaking. Well, NRB being the most obvious, but there are others as well. So, just a thought.
Well, and I take it that, I mean, even in the sort of quasi-judicial context, right, if we start to see a number of public interest cases getting litigated, we are by definition going to end up starting to see, if not rules, at least a set of factors which are going to incline the commission to find a public interest or in favor of an exclusion order or against an exclusion order, right? And the written opinion is going to sort of by definition serve that purpose. And I just, one of the notable things is that I think is we haven't seen very many of those cases in the 6 years since eBay, which is maybe surprising.
I think we're going to see more coming up soon because the November rules just, the 2011 changes to the public interest rules just took effect last year, and we're going to see the ALJs actually making decisions on public interest factors in certain cases, which presents a greater opportunity for the commission to actually rule on those types of issues on a complete record. I think you're going to see a lot more parties in the ITC developing a record, bringing in economists and the like to develop a record on the impact of potential ITC investigation on competitive conditions and consumers in the United States. So I think we're going to start seeing that just like we started to see it with domestic industry requirements.
Okay, 2 final questions.
I shouldn't be asking this because I'm not an attorney, but I have done a lot of product development. And this question of an inventor invents a product and licenses it to someone, therefore they meet the licensing requirements, versus they invent a product, they don't license it to anybody until they've taken someone to court who's already building the product, and then they get an infringement judgment against them. The person has to take a license because they've lost in court. In the first case, the product is already my invention is out there because I invented it. In the second case, the invention was out there before I invented it, or the invention was out there before I took them to court. And it seems like there's a distinction. The purpose of the patent system is to get the inventions out there. But you make a distinction between somebody, if I invent something and I license it to someone and they produce it, that's good. If I invent something and then I find someone who's already produced it and I take them to court, that hasn't necessarily done the public interest any good. So it seems like that gray area you talk about the licensing, a license that's enforced by the court as opposed to the license was the way I got the product built seems to be an important distinction. Now, maybe that didn't make any sense, but
I think one of the things that that is a backdrop for the ITC cases, which always just kind of puts it through a weird filter, is this is not, as Commissioner Aranoff indicated in her speech, right? It's not an agency designed to adjudicate patent cases, right? It's an agency designed to prevent unfair trade practices, a substantial chunk of which have now been taken the form of patent infringements. And so we've built a domestic industry requirement, not, I think, because anybody thinks in the logic of patent law that we should have patent rights depend on whether or not there's a domestic industry, but because we've got this history of an international trade statute, and so that's what sort of drives the jurisdiction of the agency.
Judge Whyte, I'm curious to know your view with respect to district court judges, given what you've just heard about the state of the law of the ITC and the, shall we say, weak stance on this public interest branch, pending any action by Congress, I guess, whether it's really gives you any pause, or district court should have some pause before granting a stay. And because that stay is going to really do an end run, do you suspect, around eBay for that particular plaintiff?
You're asking if I have any pause about granting a stay if there's an ITC proceeding?
If you suspect strongly that they're doing an end run around eBay.
I don't have any choice.
Well, you indicated that, well, apparently there's a judge in Texas who thinks there might be a constitutional question, but what if there's not a complete overlap and there is some discretion?
Well, then I think it depends on what the situation is. You have to stay that which is proceeding before the ITC if the request is made. Now, what is not overlapping with the ITC, I think you'd have to look at and see, well, does it serve any purpose to have this go forward? And I think that's really got to be looked at on an individual case-by-case basis, because I can think of situations where it clearly wouldn't be in the best interest, perhaps, of staying the whole case, in other cases where it clearly would be. So I don't know that there's any sort of hard and fast rules I could give you other than to say that I don't have any choice but to stay that which is before the ITC if requested.
And on that note, the absence of hard and fast rules, we will end. Please join me in thanking the panel.